It's AM 650's The Law Show, a comprehensive look at everything you need to know about the law. Now, here's Sterling Fox.
Delighted to have David Hobbs and Ian Giroday from Hobbs Giroday in Vancouver back in the studio for this episode of The Law Show on AM 650. By the way, David and Ian's firm is hobbsgiroday.com if you'd like to check them out on the web. We wanted to move, gentlemen, to the prime focus of this episode of The Law Show, which is protection for individuals with legal disabilities and for those who are vulnerable to abuse and undue influence. That's a pretty chewy description of what we're going to try and accomplish over the next 45 minutes or so. But let's talk about legal disabilities. What are we talking about? What disabilities fall into that category, David, in terms of protection?
Well, what we're talking about is, at the top of this discussion, is vulnerability.
Right.
People who are not able to make their own decisions and to make contracts and to look after assets and so on their own because they're disabled in some respect. The disability we're talking about is either an infant, i.e. 19, under the age of 19 years, so we consider an infant to be disabled because of their age.
Okay.
And really that's an extension of vulnerability due to their knowledge, their experience, and so on compared to an adult. The other category we're talking about is people who are incompetent, and that means that they have some medical disability that disenables them from making decisions and makes them vulnerable to being influenced or having their property impacted by other people.
And this is all in the context of a person making a will and making it, as the old cliche goes, being of sound mind and body when they do draw up that will. This is what we're talking about, people who just don't meet those criteria.
Yeah, I would extend it a little bit. It includes contracts. So a will is we don't think of a will so much of a contract, but it is a sort of contract because I'm leaving instructions to my executor to do things, and I expect the executors to do those sorts of things. The executor agrees to be the executor, so it has some element of what we think about in terms of agreement, contract, and so on.
Right.
But subject to exceptions, an infant can't make a contract. They do, and they exist in society, and people don't usually jump up and try to cancel the car that was purchased or the motorcycle or the scooter or whatever transaction at Sears or whatever because, that was an infant.
Right.
And there are reasons and exceptions for all of that. But generally speaking, infants are restricted in terms of types of contracts that they can legally make that are enforceable.
Ian, if we've talked about this in the past, in the case where an individual passes on and does not leave a will, there is law in British Columbia which basically stands in the place of a will. There's a process of administering that person's estate. Does that process apply equally to a person who, if they had an opportunity to have made a will, still couldn't have because they wouldn't have been competent to do so? Would that same administrative law take the place of a will?
Yes, it would, Sterling. If there's no will in place, regardless of the reason, whether it be a lack of capacity to make a will or just didn't get around to doing it, the Estate Administration Act would provide the process and the guidance required to determine what happens to that intestate estate.
Okay, now one of the things you fellows do at Hobbs Giroday as estate litigation lawyers is end up in court in a lot of cases trying to resolve matters between usually family members, disputes over who gets what in a will. Do you find cases, or do you try cases from time to time in which the competency of the will maker is challenged? I don't think my dad was in his right mind when he drew up that will, Your Honor, and I'd like it changed. Do you represent people like that?
Yes, that's challenging the validity of the will based on the competence of the will maker.
Correct.
I mean, the simple concept would be at the time they made the will, they didn't understand what they were doing.
Right.
They didn't understand what their estate was. they didn't understand that the will did what wills do, which has caused the distribution of the estate on death. So they're because of their mental state or their incompetence, they're lacking in these fundamental requirements and therefore can't make a valid will. And that can be asserted by someone in a lawsuit because the executor's moving forward with that will that they say is valid.
Right.
And someone stands up and says, no, I don't think it is. They file a caveat in the court registry to stop the probate of the will. They start a probate action to raise the issue of the validity of the will. And if the will is struck, then maybe an earlier will becomes the will, or maybe it becomes an intestacy. It all depends what's behind that will that's now being scrutinized.
And that kind of opens the door ever so nicely, thank you, to the whole matter of vulnerability and undue influence. Because if you from time to time are in court representing or dealing with family members who were unconvinced of the competency of the will maker in the first place, then that from time to time, I'm sure, gets colored by, and not only are we concerned this individual dad wasn't able to draw up a will, but in fact, he was influenced by this other person who, as it turns out, gets most of what was in the estate. That is undue influence, correct?
Correct. And, I give you an example. In some families, I think the wife will be the money manager and the numbers person. In other families, it may be the husband. So you can have either situation. But quite often, this starts with long-standing relationship. Maybe the person who handled the banking and the finances passes away.
Mm-hmm.
In this example, the old gent lived in an apartment building in Vancouver. His wife passed away of a 40, 50-year relationship. Obviously, he's lonely. He's aged. His health is failing. And he happens to meet somebody in the apartment building who was really just a friend of a friend, really, at that stage.
Mm-hmm.
But this individual starts to visit this person. They get a key to their apartment. They bring food. They change the photography that's lying about the building to remove the family and put that person's picture in the front and center.
Oh, really?
They bring their friends to visit. They intrude in this person's life, but the person is lonely. They're failing. Their spouse is gone. There's no children around. And you can just see the chemistry of this whole thing create a very close relationship with a new person in a very short period of time and alienate any other relationship that would have been a long-standing relationship. And this is the stirring the soup of how these things come about. And then the next thing you know, there's 6 or 7 or 8 will changes that have been made. New person has a little bit of the estate, a little more of the estate, a little more of the estate. We go see several lawyers who think they're the next lawyer doing the will and maybe don't appreciate that this person is being marched around visiting lawyers like they're, getting taxi cab rides downtown. And the whole thing and eventually, voila, this person now has the estate of this elderly person, whether by will or by joint tenancy or by changing the bank accounts or all the machinations of moving assets around.
Is this pretty common, Ian? Old people who are alone and using the circumstances that David has just described. They've just lost their lifetime partner, no children or immediate family fairly close by. Nobody shows up to visit, and suddenly somebody in the building is a new friend. And there's energy, there's freshness, there's vitality, there's a connection, and that it turns out there was a little more. It was a little more insidious than just a pleasant exchange of apple pie and chit-chat and a hockey game every now and then. There's a person on a mission to undermine an estate. Is this pretty common?
Sterling, there's a cottage industry of this sort of problem. We our older people in our society live longer now.
Yes.
They quite often their mind survives their body, or their body survives their mind somewhat.
Mm-hmm.
They're vulnerable, they're lonely, and of course we're now dealing with the baby boomers who have accumulated significant wealth in their generation, and so there's this huge transfer of wealth to occur. It's ripe for abuse. That being said, one has to differentiate between influence and undue influence.
Okay, please help us to determine that.
Right. I mean, there are, as I say, there's a cottage industry of people going around taking advantage of elderly, vulnerable people.
Fraudsters and con artists.
Sure. On the other hand, there's lots of good people out there who are helping an older person.
Right.
And quite frankly, that older person may be extremely grateful for that attention and that assistance, and may well wish to, without being unduly influenced, may well wish to reward that person through gifts during lifetime, through their will after dying. And really, it's a question of crossing that line from, perhaps the person even influencing the elderly person's decisions in that regard. Oh, it would be nice if you left me thus and so, to crossing that line of where it's no longer the free will of the will maker.
Right.
In making the directions under the will or providing the gifts and so forth.
So that's the undue part. When
Right.
you're more persuasive and pressure tactics are brought to bear on a very vulnerable old person, so that person is now making adjustments, legal adjustments to their will and so on, because of these pressures and these, literally con artist strategies.
Right. I might add as well, Stuart, we're talking, about people inserting themselves into older person's life. I would say, and I suspect David would say, we see family members unduly influencing, or at least we have cases where we're examining whether there's undue influence, more so with a family member than with a stranger.
Is that right?
Yeah.
That surprises me, because I would agree, and there's certainly an abundance of evidence to support the fact that there are a lot of nefarious bad guys out there who make a living, and quite a good one, at preying on vulnerable seniors and ripping them off for everything they can get. But I'm surprised, David, that Ian states that family members may be part of that club too.
Well, you may have 5 or 6 children in a family, and maybe one of them has a drinking problem. Maybe they've been unemployed most of their life. Maybe they have various challenges, and they see the family estate as a way out of their financial difficulties. And so when a parent passes away, they move into the house to supposedly caregive, but they pay
to the remaining parent.
But they don't pay any rent, and they don't really do much cooking or laundry, and they just kind of move in.
Right.
And then they're now involved with the investment accounts and the bank and the title to the home and eventually the assets during that aged person's lifetime is all moving into their name or jointly held with the eventually the person who passes away, leaving what we refer to as an empty estate. And so again, but it's there are very well-meaning children who move into their parents' homes and are caregivers and are honest, well-intentioned people and maybe deserve to have a disproportionate distribution of an estate because they took on that task of caring for that person who was had growing dementia or cancer or whatever illness that required home care. So it can be either story. It's a question of figuring out which one it is,
I guess, and this then you have Hobbs Giroday, experienced litigators who can get to the bottom of these and sort out who's just being a generous human being and showing concern and care for a vulnerable older person, and who's out there to rip them off.
I mean, a funny twist on one of the stories we're talking about is the concerned children or relatives contact the public guardian and trustee because they need someone to come in to interview the elderly person to make sure they are competent and do know what they're doing, and they're fearful of the behavior of someone else who's entered that person's life.
Suddenly shown up big time. Yeah.
Right, and but the public guardian and trustee may have a nice little meeting with the elderly person, be satisfied they're competent. They may not be 100%, but they're not incompetent. And then the aged person is now offended and angry that someone would contact a government authority, have them come to their home, interview them, and
stick their nose into my life.
Well, and suggest to them that maybe they're incompetent when they're not.
Right, right.
And then the interloper may say, well, that wasn't very nice of them to do that. I'm really your friend, not them,
right.
Aren't I? And so the whole intention of trying to prevent something bad happening turns around against the people who are well-intentioned, and
right.
So it can get very complicated.
So Ian, let's talk about that, because now we're the boomers, and we're looking, and we're deeply concerned about the welfare and well-being of our parents, who are now in their 80s and 90s, and we are suspicious. All of a sudden, there's something different about Mom. Dad's long gone; she's by herself, and there's this new friend. Which is great, we're usually appreciative of fresh energy and companionship in her life. But this new friend, in quotes, is kind of different. And we're more than a little suspicious, and it's not mercenary. It's not that, we may not get some good coin in the will or anything. This guy's just weird, and he's just arrived, and all of a sudden there's a presence in her life that we're concerned about. What can we do? You can't call the cops because there's no crime that you're aware of, and yet you can just feel it in your gut. This is wrong. This person is here for all the wrong reasons. What can we do?
Well, if you're nearby, of course, you can pay more attention to your elderly parent and sit down with your parent and try and understand what the situation is. When people come to us with these concerns, we're looking for various facts.
Okay.
To get a sense of what's going on here. So we're looking at things like, is the person who's come to see us, are they aware of long-standing estate plans that they may know now have been
recently altered?
Radically altered.
Right, right.
Do they still have unfettered access to their parent? Or is it somehow being controlled or monitored by this
new person,
interloper?
Yeah.
When they go and visit their parent, are all the family photographs still up on the mantle and on the wall, or are they down or replaced?
Right.
Is there any sense that the telephone calls are being screened? So there's lots of, and there's many more, but those are the sorts of things that one should be considering. And certainly dealing with the parent at the personal level, at the family level, is much preferable than, for example, getting the public trustee involved in the first instance.
Right. I want to take a break, and when we come back, David and Ian, I would like to talk about the whole matter of the public trustee and the guardian, and also the power of attorney, because I get the feeling that's the key that opens the vault in a lot of these cases. This is The Law Show on AM 650 on this Sunday morning. David Hobbs and Ian Giroday from Hobbs Giroday in Vancouver, online at hobbsgiroday.com. Back with more after this.
There's more of the show still ahead. This is AM 650's The Law Show.